Hello friends, welcome to our channel Steno. Subscribe our channel for more dictations on daily basis. I will dictate a full passage without any stop. So take frequent break and write responsibly. Get ready for the dictation. A related witness cannot be termed as an interested witness per se. One has to see the place of occurrence along with other circumstances. A related witness can also be a natural witness. If an offence is committed within the precincts of the deceased, the presence of his family members cannot be ruled out as they assume the position of natural witnesses. When their evidence is clear, cogent, and withstood the rigor of cross-examination, it becomes sterling, not requiring further corroboration. A related witness would become an interested witness only when he is desirous of implicating the accused in rendering a conviction on purpose. When the court is convicted with the quality of the evidence produced notwithstanding the classification, it becomes the best evidence. Such testimony being natural, adding to the degree of probability the court has to make reliance upon it in proving a fact. Once again, we reiterate with a word of caution, the trial court is the best court to decide on the aforesaid aspect, as no mathematical calculation or straitjacket formula can be made on the assessment of a witness, as the journey towards the truth can be seen better through the eyes of the trial judge. In fact, this is the real objective behind the enactment itself, which extends the maximum discretion to the court. A mere non-examination of the witness per se will not vitiate the case of the prosecution. It depends upon the quality and not the quantity of the witnesses and its importance. If the court is satisfied with the explanation given by the prosecution along with the adequacy of the materials sufficient enough to proceed with the trial and convict the accused, there cannot be any prejudice. Similarly, if the court is of the view that the evidence is not screened and could well be produced by the other side in support of its case, no adverse inference can be drawn. Onus is on the part of the party who alleges that a witness has not been produced deliberately to prove it. There are three eyewitnesses examined by the prosecution. We find PWs 1 and 2 have not contradicted between themselves being the eyewitnesses. Merely because they are related witnesses in the absence of any material to hold that they are interested, their testimonies cannot be rejected. There is also no delay in the registration of the FIR. PW3, though turned hostile, spoke about the incident in his chief examination. Strangely, in the cross-examination, he turned turtle while disputing the very factum of his chief examination made before the court. We do not wish to say anything on the credibility of the said witness in view of the evidence of PWs 1 and 2. The view of the courts on this witness also deserves to be accepted. The High Court has rightly set aside the conviction rendered by the trial court for the charge under Section 307 IPC. PWs 1 and 2 have not spoken about the presence of the injured witness Om Prakash. The circumstances under which he could not be produced was explained by the prosecution. Merely because he was not produced, the entire case of the prosecution would not become false. The FSL report was placed on record. Both the courts have considered and relied upon the said report. The entire circumstances under which the material was collected, including the cartridges, also with the recoveries made which were sent to the expert, have been explained by the official witnesses. We do not find anything unnatural in the testimony. On a perusal of the evidence available, we do not find any delay in either sending the recovered arms to the expert or receiving the FSL report. The circumstances under which they were sent and received were spoken about and explained. The appellants have neither shown any prejudice being caused by the alleged delay nor have disputed the findings of the said report. The learned counsel appearing for the appellants submitted that the investigating officer could not be cross-examined further with respect to the injuries and the recoveries. We find that evidence was also let in to that extent along with the cross-examination. The High Court has considered this aspect in the correct perspective. It is very unfortunate that the investigating officer could not be produced despite the best efforts made. The reason is obvious. There are three investigating officers. The other two investigating officers have been examined, including for the charge under the Arms Act. PW 13, the first investigating officer, has been examined in extenso during cross-examination. It is only for the further examination be turned turtle that per se would not make the entire case of the prosecution bad in law, particularly when the final report itself cannot be termed as a substantive piece of evidence, being nothing but a collective opinion of the investigating officer. The trial court as well as the High Court considered the evidence threadbare in coming to the right conclusion. Similarly, the contention that there is no explanation for the existence of some other empty cartridge recovered from the place of occurrence would not facilitate an acquittal for the appellants, as there are materials sufficient enough to implicate and prove the offence against them. Thus, on the aforesaid conclusion arrived at, we are in conformity with the well-merited judgment of the High Court. The appeals stand dismissed.